Welcome to this podcast on the case of John Worboys. Dubbed the Black Cab Rapist with possibly more than 100 victims, John Worboys has been a cause for great concern after the parole board approved his release earlier in January 2018. The decision is now subject to a judicial review application, the first hearing set to take place next week on February 7th, 2018. In this podcast, I'm going to go over the facts of the case, the sentence, and what the sentence means. I'll also look at whether the law should be changed to enable the parole board to publish their decisions. Turning to the facts of the case, John Worboys was a black cab driver operating in the West End of London. Between 2002 to 2008, Worboys would look specifically for taxi fares that were women who were alone and vulnerable. His modus operandi involved giving champagne laced with a sedative to these women, explaining that he was celebrating money won at a casino or on the lottery. Once the women were inebriated, Worboys would sexually assault his victims. At trial, he was charged with 23 counts, 2 being alternative charges, and there were 14 complainants in total. He was convicted of 19 offences relating to 12 complainants at Croydon Crown Court and acquitted of 2 offences. The 19 offences are as follows: 1 count of rape, 1 count of sexual penetration, 4 counts of sexual assault, 1 count of attempted sexual assault, 12 counts of drugging, presumably under Section 61 of the Sexual Offences Act. Turning to the sentence, Worboys was sentenced on the 21st of April 2009 and was given terms of imprisonment for public protection, known as an IPP, on all counts. He received an indeterminate sentence to serve a minimum of 8 years imprisonment. This would mean the judge considered the sentence in effect to have been 16 years. In a normal imprisonment sentence, an offender would serve half of the sentence in prison and the remaining half on licence. In effect, this works the same way with the tariff. To briefly explain IPP sentences, it's important to note that IPP sentences are no longer used. They were used between 2005 and 2012. Their intention was to ensure that dangerous, violent and sexual offenders were not released until the parole board considered those offenders to no longer be a risk to the public. Where a person was convicted of a specified violent offence or sexual offence, they would receive a tariff. A tariff is perhaps more easily thought of as a minimum term. At the end of the tariff, the offender applies to the parole board and must satisfy the board that it is safe for them to be released to the public. The burden of proof is on the offender to satisfy the parole board that they no longer pose a risk. In terms of answering how a sexual offender might demonstrate they're no longer a risk, according to Matthew Stanbury in a post from Garden Court Chambers, normally this would be demonstrated by completing a sexual offenders treatment programme. The parole board must look at all the evidence, including the offender's behaviour in prison and their progress in making the decision. So was the sentence unduly lenient? A sentence is unduly lenient where it falls outside the range of sentences which the judge, applying his mind to all the relevant factors, could reasonably be considered appropriate. Sentencing guidelines were a relatively recent tool in the criminal justice system in 2009. The Ministry of Justice suggested that sentences for sexual offences are 30% longer on average now than they were in 2010. The current guidelines suggest that a starting point for a campaign of rape is 20 years and above. However, the 2007 guidelines, to which Worboys was subject, gives a starting point for repeated rape of multiple victims being 15 years. Worboys was not sentenced for the repeated rape of multiple victims, as he was only convicted of 1 count of rape. Nevertheless, he was still given an IPP, and one which was effectively a sentence of 16 years, close to the starting point of a sentence for repeated rape of multiple victims. It would appear the sentence to be on the right track then, considering the context of the offences. Even in the alternative, where the sentence is to be considered unduly lenient, that decision should have been made long ago. A referral must be made within 28 days of the date of the sentence. This therefore expired on the 19th of May 2009. Equally, the function of the parole board is not to extend or shorten sentences, nor is it to consider whether sentences are unduly lenient. The sentence is decided by the judge, and the matter for undue leniency is that for the Attorney General. At this time, it was Lady Scotland. She reviewed the case and decided that it was not unduly lenient. So what does the parole board actually decide? Well, the parole board exists under the Criminal Justice Act 2003 under Section 239 and Schedule 19. It's responsible for conducting risk assessments of prisoners to determine if they can be safely released into the community. An oral hearing may be required prior to making the decision. So why has John Worboys now been released? Well, the tariff of 8 years has been served, and he's satisfied the parole board that he's no longer a risk to the public anymore. Worboys has actually served 10 years when the time spent in custody on remand is taken into account, which normally is. As for Worboys' specific parole hearing, the chair of the parole board stated that there was a 3-member panel chaired by one of the board's most experienced women members, as well as a psychologist on the panel. A dossier of 363 pages was considered, and evidence from 4 other psychologists was heard, alongside evidence from prison and probation staff responsible for Worboys. It made the decision, after considering the evidence, that he was safe to release. The reasons for the release are not published, but why not? Well, the answer is that it's against the law. Rule 25 of the Parole Board rules states information about proceedings under these rules and the names of persons concerned in the proceedings must not be made public. An exception to Rule 25 is where a prisoner brings a claim for judicial review of a Parole Board decision. Those proceedings will normally then be heard in public. This is how many Parole Board decisions find their way into the public domain. But should the law change? Should there be a change to Rule 25 to allow the publication of Parole Board decisions? Well, Chair of the Parole Board, Nick Hardwick, has expressed support for such a change, making proceedings more open. This would allow for greater understanding to why a Parole Board decision has been made. It would also leave the victims in a better position to challenge a decision by judicial review, where a case much like the Worboys case results in widespread public condemnation. Matthew Parris, however, argues the contrary. He states that there would be little reason in disclosing decisions that were nevertheless final. There is currently no method of challenging or appealing such decisions other than by judicial review. This would consequently result in the demand for a new body to be established to consider appeals. This may come at enormous cost to the budget of the Ministry of Justice, which has suffered massive cuts and already struggles to deal with its existing caseload. There would also be a requirement to redact sensitive and private information about victims, as well as medical opinions and the private circumstances of offenders, which may remove the essence of the decision to begin with. This also may result in a continuing process of appeal and appointing committees to reveal the redactions, not actually solving the matter of making the public more informed. Well, the headlines speak of hundreds of victims, so where does this number actually come from? Well, it comes from a civil case. One of the earliest victims successfully sued the Metropolitan Police for failing to investigate her complaint properly, and the judge, in that case Mr. Justice Green, accepted the number of 105 victims in his judgment. It's important to remember that the civil standard of proof that Justice Green applied in his case was much lower than the criminal standard. The balance of probabilities was applied in the civil case, and the much more substantial beyond reasonable doubt is required for a criminal conviction. Therefore, Justice Green essentially stated that it was more likely than not that Worboys attacked 105 women. Naturally, it's essential to the criminal justice system that criminal convictions and punishments are not handed out to those who have only probably done what they're accused of doing. That will invariably leave the question of why the complaints of the remaining victims, though, were not prosecuted. The CPS has released a statement, and they've explained the following factors. They said during the investigation, files related to about 83 separate complainants were referred to the CPS. Of those 83, 14 complainants formed part of the trial. The rest of the cases did not pass the evidential test. Now, the evidential test is that the prosecution must consider there to be enough evidence to provide a real prospect of conviction. Prior to the trial, a further 3 complainants were seen to have passed that evidential test, but not joined to the indictment because the existing charges were considered enough to enable the judge to pass what they deemed to be an appropriate sentence. The maximum sentence for rape is life, the maximum sentence for sexual assault is 10 years, and the maximum for administering a substance with intent is 14. The additional convictions for those offences, those particular 3 offences, was considered unlikely to have made a significant difference to the overall sentence. Matthew Scott, a criminal barrister of Pump Court Chambers, argues that there's more to prosecuting than bombarding the jury with all the possible evidence, and that there's an art to finding the right balance between too little evidence and overcomplicating a case with unnecessary charges and evidence. Adding complexity, he argues, also gives way to vulnerability and for further things to go wrong. Adding weak counts to an indictment can be counterproductive to the strength of the case as a whole. The way in which Worboys actually carried out his offences created a significant evidential problem in themselves. The drugs that he used on his victims actually fractured their memories and made it very difficult for them to identify Worboys later. Scientific evidence was also scant or non-existent, partly because the women complained a long time after the event. It's always unknown as to why the jury comes to the decision it makes, but it might be fair to presume that the jury did encounter some evidential difficulties as they actually acquitted Worboys on 2 charges. Aside from any issues of parole or appropriateness of sentence, one of the great mistakes here was actually the failure to inform the victims of Worboys' release. Informing the victims of the key stages of his release was something which should have happened. The chair of the parole board accepts this in a statement and has described it as very concerning and acknowledges that it would be very distressing that the victims were not kept up to date. The victim contact scheme is offered to those who have been the victim of sexual assault or violent offences resulting in a sentence of 12 months or more. This particular scheme entitles victims to be informed of the key stages of the offender's sentence, such as their release and their transfer to open conditions, as well as licence conditions, to which the scheme enables them to make representations on. The Code of Practice for Victims, known as the Victims Code, gives victims certain rights post-trial, which include the ability to make a victim personal statement, which can be considered by the parole board. The Victims Practice Code in general does apply to those whose complaint has not resulted in a conviction, but only a complainant whose complaint has resulted in a conviction would have the right to make a victim personal statement in this case. This would mean of the 105, only those involved in the trial whose complaints resulted in convictions would have the opportunity to draft a victim's personal statement, which would then be considered by the parole board. The others would not have that opportunity. It should be noted that it is the National Probation Service, not the parole board, that has the responsibility to ensure that victims who wish to make a VPS can, and complainants are kept informed. So what happens next? Well, Worboys is currently in prison. A stay on his release was granted after an application was made to the High Court on the 22nd of January 2018. As of recording this, on the 2nd of February 2018, the first stage, where the judges will consider whether to allow Sadiq Khan, the Mayor of London, and 2 of Worboys' victims to apply for a judicial review, will take place on Wednesday, the 7th of February 2018. It might be interesting to ask, will they obtain permission to proceed with judicial review? A victim could bring a judicial review claim, but they face the challenge of not knowing the reasons for the decision. You're not able to challenge a decision by way of judicial review unless you know what the decision says. Without knowing the details of a decision, you're simply unable to say whether it was the right decision or whether it was the wrong decision. There are questions of standing when it comes to victims bringing judicial review cases as well, but this is perhaps a more complex matter for another discussion. Normally an offender brings a judicial review, though clearly in this case, Worboys would not bring a judicial review challenging the decision that he is safe to be released. That concludes this podcast, and thank you very much for listening.